Good morning, everyone. We're going to get started. Looks like we're just beginning to record. So good afternoon and welcome to our quarterly CEO Roundtable. My name is Zenobia Harris and I am the CEO for the Kent Chamber of Commerce. Before we get started, I just wanted to go over a few housekeeping items. This webinar is copyrighted and presented by the Kent Chamber of Commerce and may not be reproduced or retransmitted in any form without the express written consent of the Chamber. This meeting is also being recorded but not streamed live. Today we have Washington State Department of Labor and Industries presenting the Employer Guide to Workers' Rights webinar, where you will learn about workplace rules and regulations enforced by the Employment Standards Program at L&I. The Employment Standard Outreach Team today will present on wage requirements, tracking hours of work and record-keeping requirements, minimum wage, overtime and tips, paid sick leave and other protected leave requirements. They will also talk about youth employment and workplace right compliant processes. This presentation will also be followed by a 15-minute question and answer session. Today we have three presenters. We have Robert Joy, Tiffany Richard, and Sylvia Cardenas with L&I. Robert Joy, Tiffany, and Sylvia are Employment Standard Outreach Specialists for Washington State Department of Labor and Industries. This team conducts outreach to the public and internal staff on the rules, regulations, and processes. In addition to these effective outreach efforts, they also work diligently to create tools, resources, and guidance for internal staff member as well as external stakeholders. So with that being said, I will turn it over to Sylvia.
Thank you, Zenobia. And thank you, Kent Chamber of Commerce members, for being here today and joining us on our Employer Guide to Workers' Rights presentation. Today's presentation is an introduction to the Employment Standards Program, more specifically the laws the department enforces when it comes to wage and hour. My name is Sylvia, and I'm one of three Employment Standards Specialists at the Department of Labor and Industries who will be presenting to you today, but I'll pass it over to the team so they can introduce themselves as well.
Hello, good morning. My name is Tiffany Richard, and I'm also an Employment Standards Outreach Specialist, and we're excited to be able to join you and present this information to you.
And good morning, I'm Bob Joy, and I'm the other Outreach Specialist with Employment Standards.
Thanks, team, for those introductions. Now, during the presentation, you may have some questions, and we encourage you to use the chat box function here on the Zoom platform. We will be trying to answer your questions during the presentation, but just know that if we don't get to your question right away, we have that allocated time at the end of the presentation to answer any of those outstanding questions. And just a quick note, if one of our presenters starts to have some audio issues, we'll briefly interrupt just to make sure that the audio quality is working for this presentation. So thanks again in advance for your patience and understanding while we present on this online platform. So now let's get started here. The goal here today is to help you understand the requirements to comply with wage and hour laws and other workplace protections enforced by the Department of Labor and Industries. So whether you have 1 or 1,000 employees, we hope that the information in this presentation will help you utilize the resources and contacts that are available to you. The Department of Labor and Industries' mission is to keep Washington safe and working. Our Employment Standards Program enforces child labor laws, laws that protect workers' wages and working conditions, and that employees are provided the other employment standards protections that they are entitled to. All employees in the state of Washington are protected by the regulations enforced by the Department of Labor and Industries, regardless of their legal status or amount of hours that they work. Here is an overview of the many topics we plan to cover today. As mentioned, we'll be reviewing the pay requirements, a review of specific regulations, the worker rights complaint process, and of course, resources for you to have. All right, so let's get started with a quick review of the Minimum Wage Act protections, which include the right to earn at least minimum wage for all hours worked, the right to overtime for hours worked over 40 per work week, the right to earn tips and service charges, the right to accrue and use paid sick leave, and protection from retaliation and discrimination for exercising protected rights under the law. These protections apply to most employees, except those who are specifically exempt from state law. Employees must be paid at least minimum wage for every hour worked, and as of January 1st, 2021, the minimum wage rate is $13.69 an hour. Workers under 16 years old may be paid 85% of the minimum wage, and some local jurisdictions have higher minimum wage rates and different labor rules than Washington State. The more generous minimum wage may apply in these localities, such as Seattle and SeaTac. Most employees who work more than 40 hours in a 7-day work week must be paid overtime. Overtime pay must be at least 1.5 times the employee's regular hourly rate, and employees cannot waive their right to overtime pay. Some employees must meet a specific exemption in the law to be exempt from overtime. The most common overtime exemption applies to white-collar salaried workers in an executive, administrative, professional, computer professional, or outside sales roles, and also most agricultural workers and individuals who do meet the definition of employee under the Minimum Wage Act. And here below, we have the link to our jobs that do not pay overtime, and we'll be sending this presentation out here so that everyone has the information available to them. General, executive, administrative, professional, computer professional, and outside sales employees can be exempt from overtime and other Minimum Wage Act protections. Both state and federal regulations generally use this 3-part test to determine if an employee is exempt. A salary basis test. The employee must be paid a predetermined fixed salary. A salary level test. The amount of salary must be a minimum specified amount. And a duties test. The employee's job duties must primarily involve executive, administrative, or professional duties as defined by the regulations. And for more information, again, we've included our online website link below for questions in regards to this particular topic. And when it comes to overtime, there's, excuse me, 2 steps to calculating the overtime for an employee. So first, we must determine the employee's regular hourly rate. An employee's regular hourly rate is calculated by adding together their weekly compensation and dividing it by the total number of hours that they work during that week. Then we multiply that regular hourly rate by 1.5 for every hour worked over 40 hours in the work week. Now, we're briefly going to review the tips and service charges information. Tips are amounts freely given by a customer to an employee. Employers must pay all tips due to an employee, and they cannot be counted towards a state minimum wage. Employers must ensure that they do not take tips for company use or to pay employees' wages. And a service charge is a separate designated amount of money collected by employers that appears to be for services that an employee provides. The service charge requirements are to specific businesses, including but not limited to restaurants, catering houses, convention centers, and overnight accommodations. Service charges are in addition to hourly wages paid to the employees serving the customers. And under state law, an employer that imposes a service charge to a customer must disclose on the receipt and menu how much and if any portion of a service charge is not clearly designated as being retained by the employer, it is due to the employee or employees serving the customer. The Equal Pay and Opportunity Act. So this is a recent law that took effect in June of 2018 and was expanded in 2019. The Equal Pay and Opportunities Act prohibits gender pay discrimination and promotes fairness among workers by addressing business practices that contribute to income disparities between genders. Both employees and job applicants have rights under this law. These are the rights that employees have under this law. Employees have the right to equal pay, not based on gender, and equal career advancement opportunities, not based on gender. The law lists some permissible bona fide factors to justify different compensations or promotional opportunities, but gender cannot be one of them. Some of those bona fide factors include education, training, experience, having a seniority system, a merit system, or based on job performance. Employees have the right to have open wage discussions with others and access to wage or salary information of a new position or promotion upon request by the employee. This requirement does not apply to employers who have fewer than 15 employees. And employees have the protection from retaliation. An employer cannot take an adverse action against an employee for exercising the right under this law. Now, these are the protections for job applicants under this law. Job applicants have the right to be provided the minimum pay rate or salary range upon request by the applicant after a position is offered to them. This requirement does not apply to employers with fewer than 15 employees. Job applicants have the right to wage and salary history privacy. Employers cannot seek the wage or salary history of an applicant. An employer may confirm an applicant's salary after the employer negotiates and makes an offer of employment, including pay to the applicant. Job applications cannot ask for an applicant's previous salary, even if that section is not required or optional. Employees can voluntarily disclose their wage or salary history to prospective employers. There is also protection from wage and salary history requirements. Employers cannot require that an applicant's prior wage or salary history meet a certain criteria or require that an applicant made a minimum amount previously in order to be considered for a new position. And now I'll hand it over to Bob to go over the pay requirements.
Thank you, Sylvia. Employees must be paid for all work performed at the rate agreed upon with their employer. This rate can be an hourly wage, hourly, flat rate, salary, piece rate, commission, or a combination. When an employee is paid hourly, they must be paid for all hours worked. There are three elements to the definition of hours worked. 1, an employee is authorized or required by the employer. 2, to be on duty. And 3, on the employer's premises or the prescribed workplace. If any of the three elements is not satisfied, then the time spent is not considered hours worked. An analysis of hours worked must be determined on a case-by-case basis, depending on the facts. Hours worked can include travel time, which may be compensable depending on the specific facts and circumstances of each individual employee, employer, and work week. If the travel or commute time is considered hours worked, it is compensable and the employee must be paid for this time. These statutory and regulatory requirements cannot be waived through a collective bargaining agreement or other agreement. Required training and meeting time, which is generally interpreted to mean all time spent by employees attending lectures, meetings, employee trial periods, and similar activities required by the employer or required by state regulations. Time spent by employees in these activities need not be counted as hours worked if all of the following tests are met. Attendance is voluntary. The employee performs no productive work during the meeting or lecture. The meeting takes place outside of regular working hours, and the meeting or lecture is not directly related to the employee's current work. Wait time. In certain circumstances, employees report for work, but due to a lack of customers or production, the employer may require them to wait on the premises until there is sufficient work to be performed. Waiting time is all time that employees are required or authorized to report at a designated time and to remain on the premises or at a designated work site until they may begin their shift. During this time, the employees are considered to be engaged to wait, and all hours will be considered hours worked. On-call time. Whether or not employees are working during on-call depends upon whether they are required to remain on or so close to the employer's premises that they cannot use the time effectively for their own purposes. And time for putting on and taking off uniforms or personal protective equipment. Preparatory and concluding activities are those activities that are considered integral or necessary to the performance of the job. Those duties performed in readiness and or completion of the job shall be considered hours worked. When an employee does not have control over when and where such activities can be made, such activities shall be considered as hours worked. Employees and employers may come to agreements related to payment that is more favorable than state law. These arrangements are considered an agreed wage. An agreed wage can include many different types of pay, including normal hourly rates of pay or premium rates of pay for certain tasks or shifts. This can include shift differentials, hazard pay, double time on holidays, on-call pay, and the like. The agreed wage must be included in any overtime calculation when overtime eligible employees work more than 40 hours in a work week. Paychecks. Employers are required to pay employees at least once per month on a regular scheduled payday. An employer may require employees to sign up for a direct deposit as long as this does not impose a cost on the employee. Employers may also offer to pay employees using debit or prepaid payroll cards. If there are fees for using these cards, then the employer must provide an alternative that allows the employees to access their wages without any fees or costs associated when withdrawing funds. If an employee quits or is fired, their final paycheck must be paid on or before the next regularly scheduled payday. Employers cannot withhold a final paycheck if the employee does not turn in keys, uniforms, tools, equipment, etc. Withholding final paychecks is a violation of state employment law and may subject the employer to enforcement actions and penalties, no matter how egregious the cause may be. Paying employees beyond their hours worked is generally not required unless there is a specific agreement between the employee and the employer, or if it is required by a collective bargaining agreement. State law does not typically require the following types of payment. Show-up pay. Employers are not required to pay employees if they report for their shift until they are not needed to work. Only actual hours worked must be paid. On-call pay. Employers can require an employee to be on call and available to work on an emergency or as-needed basis. Employers are generally not required to pay employees who are on call, unless the employee is actually called to duty. However, if an employer places significant restrictions on how an employee spends their time on call, this time may need to be compensated as hours worked. And finally, reimbursement or fixed rates paid for meals and lodging while traveling, often called per diem, is not required by state law. Additionally, reimbursements for fuel, parking fees, tolls, and other purchases made by the employee for the business are benefits given by the business at its own discretion. The following deductions may be made even if the deduction takes the employee's wages below the state minimum wage and are done during ongoing employment. Deductions required by state or federal law, such as federal income taxes, Medicare, workers' compensation. Court-ordered wage garnishments. Deductions that benefit the employee when the worker has agreed to the deductions in advance. And when these deductions are made during ongoing employment, the agreement must be in writing. And deductions for medical, surgical, or hospital care or service. For any of these deductions, employers may charge retail prices and reasonable interest for loans, but they cannot otherwise financially profit or benefit. The following deductions are allowed only when there is an oral or written agreement between the employee and the employer, and the incidents described occurred during the final pay period. For covering a cash shortage in the till, if the business has established policies regarding cash acceptance, the employee has sole access to the till, and the employee counted the cash at the start and end of the shift. For covering the cost of lost or damaged equipment, if the equipment damage or loss can be shown to be caused by the employee's dishonest or willful act. For acceptance of an NSF check or credit card purchase, if the business already has policies for check and credit card acceptance at the time of the incident. And for worker theft, if the employee's actions are shown to be dishonest or willful and the employer files a police report. These deductions may not take the employee's wage below the state minimum wage. It is the employer's responsibility to prove the employee's alleged actions and the existence of any policy, agreement, or procedure. Employers should notify employees of all policies, agreements, and procedures for final paycheck deductions, and these policies should be made in writing and signed by the employees. During an ongoing employment relationship, employers cannot deduct any of the following: reimbursement for a customer's bad check or credit card, cash register shortages, even when an employee counts their till at the beginning and end of the shift, has sole access to the cash register, and is short at the end of the shift, customer walkouts, theft or unpaid bills, and damages or loss of company equipment. Washington state law requires employers to keep employees' payroll records for at least 3 years. Employees have the right to request copies of these records at any reasonable time. The employer can keep the records in either an electronic and/or written format. Payroll records must contain the employee's information as shown on the right side of this slide. Full name, home address, employment start date, rates of pay, total wages earned. You must keep additional records if you have employees under 18. Upon request, employers must make payroll records available to the employee within a reasonable period of time, usually within 10 business days. The employee must be allowed to inspect, review, transcribe, or photocopy the records at their usual place of employment. And L&I may request payroll records in the event of an investigation. If an employer fails to produce the required records, L&I may rely on personal records of an employee involved in the investigation. Itemized pay statements, commonly known as pay stubs, are a record of a worker's earnings in a pay period. Pay stubs must be provided either electronically or on paper each pay day. If an employee cannot receive an electronic pay statement, then the employer must provide a written one. Employers must include the following details on each pay stub: the pay basis, rate or rates of pay, the gross wages, all deductions for that pay period, and all records required for paid sick leave. For agricultural employers, there are additional pay stub record-keeping requirements. For more information, please go to the information link indicated at the bottom of this slide. And now Tiffany will address meal and rest breaks and leave.
All right, so we're about halfway done through our presentation. I just want to check in. I do see that there's a question in the chat box, so we'll make sure to get to that. But I just want to make sure that if you have any more questions, to feel free to continue to add those to the chat box as we're going through. So now we're going to get into rest period requirements. So employers must provide their employees with rest periods, and there are certain requirements for these. So rest periods must be paid to employees, and this is defined as on the employer's time, and they must be a minimum of 10 minutes for every 4 hours worked. And you can choose to give your employees a rest break for more than 10 minutes, but just know that this is the minimum amount that the law requires, at least 10 minutes. And again, it must be a paid rest break, so this means that the employee is free from duties and are not required to work during their rest break. Employees cannot be required to work more than 3 hours without a rest break, and because these are paid required breaks, employees cannot waive the rights to their rest breaks. And we just want to emphasize that now more so than ever during COVID, these are very important breaks for employees to take, and they do have rights under the law to receive them. So now we're going to go into meal breaks and what those requirements are. So meal breaks are usually not required to be paid, and we say usually because there are instances in which you do need to pay employees for meal breaks. For example, if you require employees to remain on duty during their meal break or to remain on call on the premises in your interest, even if they are not called back to duty, this would be considered hours worked because they would be performing work or interrupting their meal break, or they would have that expectation of remaining on call on the premises. So in that instance or any of those situations, you would need to pay the employee for their meal break. However, you are not required to pay an employee for their meal break if the employee is free from all duties for the entire duration of their break. And unpaid meal breaks are not considered hours worked. Meal periods must be at least 30 minutes in length and must be given if an employee works beyond 5 hours into a work shift. Employees must receive a meal break after the 2nd hour and before the 5th hour into the shift. So an example could be if an employee is working a shift from 12 to 6, so a 6-hour shift. If we're following these steps here and these regulations for meal breaks, the employees should get their lunch break after 2 p.m. and before 5 p.m. So around 3 or 4 o'clock, just to give an example. And unlike rest breaks, employees over the age of 18 may mutually agree to waive their meal breaks. But please know that even if you do get a waiver from the employee, at any time if they express their desire or their rights to have their meal break for that day, then that would supersede any type of written agreement that you have a waiver, because these are rights that employees have under the law. So in those cases, you would still require you would still be required to give the employee their meal break if they exercise their right to receive it. And these are the standard requirements for meal and rest periods, but please note that there are separate distinct requirements for minor employees and agricultural workers. And here's the link below where you can find more information. All right, so now we're going to talk about paid sick leave. As many of you know, as of January 1st, 2018, most employees are now entitled to 1 hour of paid sick leave for every 40 hours worked. And this includes part-time employees as well as employees that are hired on a temporary basis. Workers that are exempt from the definition of employee in the Minimum Wage Act are exempt from paid sick leave as well, since paid sick leave falls under the Minimum Wage Act definition. So this would include a bona fide exempt white collar, executive, administrative professional, computer professional, and outside sales employees. Sick leave accrual begins immediately on hire, and employees may start using their earned paid sick leave 90 days after their first day of work with their employer. Employees may use their paid sick leave to care for themselves or for their family members, such as a child, parent, spouse, grandparent, grandchild, or a sibling. They can also use accrued paid sick leave if their child's school or place of care is closed for a health-related reason. Like in recent cases where there were government-mandated school closures due to COVID-19, employees would have the right to use their paid sick leave for such authorized purposes. They can also use paid sick leave for absences related to domestic violence. And here we have a link to our website, which has more information on paid sick leave in relation to the coronavirus outbreak. Now, there are certain notification requirements that employers also must follow for paid sick leave. First, employers must provide employees with a one-time written or electronic notification outlining their paid sick leave rights, and this information must be readily available to all employees and provided to them no later than their first day of employment. Employers must also provide employees with regular statements at least once a month to include amount of paid sick leave used, paid sick leave accrued, amount used, and balance remaining for use. The employer can decide how they're going to inform the employee of these totals. For instance, some employers will decide to provide this information on the employee's pay stub or may have an online system where employees can easily access this information. So whatever the method you decide, it is up to you. Just know that it has to have this required information and be provided to employees at least monthly. Employees may carry over up to 40 hours of unused paid sick leave into the following year. However, they may choose to adopt a more generous carryover policy than what the law requires. And employers do not have to pay out unused leave at termination, but must reinstate any previously accrued unused paid sick leave if they rehire an employee within 12 months of their separation. So let's say there's an employee that you have that's working for the company, and they separate employment and come back, or they're rehired within 6 months. Even if they are rehired at a different location, if they're rehired for the same employer, then you would need to reinstate their paid sick leave at that point that they're rehired because it hasn't exceeded the 12 months. However, the employee's accrued paid sick leave hours do not have to be reinstated if it was cashed out or paid to them in full when their employment ended. And we know that this is kind of a hot topic here. So if you have more in-depth questions too, we have our paid sick leave specialist information here. If you'd like to reach out to him for more information. So next we're going to go over several laws that provide protected leave to employees. The first is the Washington Family Care Act, also known as the FCA. So the FCA allows employees to take any paid leave offered by their employer to either provide treatment or supervision for a child with a health condition or to care for a qualifying family member with a serious or emergency health condition. So employees can choose the type of paid leave benefit they want to use, such as paid sick leave or paid time off. For instance, let's say an employee has 20 hours available of paid sick leave. The employee has the right to use those paid sick leave hours to care for their child who has a medical condition because it is a paid leave that they already have available and they would have access to use that. So FCA is not a separate leave, but it is available for employees to use other types of paid leave benefits that they have. So this can be vacation leave, like I mentioned, paid time off, paid sick leave, personal holidays, comp time, specific short-term disability plans, or other leave benefits that are applicable. Leave under the FCA is not available for an employee's personal medical condition. It is only available for use for a qualifying family member. Another protection is the Washington Domestic Violence Act, which provides reasonable leave for victims of domestic violence, sexual assault, or stalking, or their family members. So victims and their family members can use domestic violence leave for legal or law enforcement assistance in court proceedings, medical and psychological help, help from social service programs, safety planning, or relocating. Next, we have leave for spouses of military personnel. So after receiving a notice of impending call or order to active duty, the employee who is a spouse of a military member may take up to 15 days leave per deployment. So their spouse must be a member of the Armed Forces or National Guard to be eligible. And this leave also applies to reservists who have been called to active duty. And this is used for either before or during deployment, allowing spouses the ability to spend time together. And lastly, we have leave for certain emergency services personnel. So employers with 20 or more full-time employees must allow employees who serve as voluntary firefighters, reserve peace officers, or civil air patrol members to arrive late or be absent from work because they are currently working at or returning from a fire alarm or emergency call. However, they do not qualify for this leave once they have started their scheduled workday unless the employer specifically agrees to provide such an accommodation. And some employers do choose to provide vacation, holiday, and bereavement leave, but just know that this is more general than what the law requires. So these types of leave are optional benefits that as the employer you can offer employees, but you are not required to do so under the law. And we'll have Bob take us into our next topic.
Thank you, Tiffany. Agriculture labor includes work performed on a farm, including soil cultivation, raising a crop, handling livestock or other farm operations, or in packing, packaging, grading, storing, or delivering to storage. Agricultural workers must earn at least the state minimum wage for all hours worked, regardless of payment method. Some agricultural workers are exempt from overtime. Immediate family members of agricultural employers, such as children of farm owners that work on the family farm, are still subject to wage and hour requirements. However, they may be exempt from certain non-wage agricultural employment requirements. For more information on agriculture labor questions, see the link at the bottom of this slide or contact the LNI Agriculture Specialist, Christina Rodriguez, at the phone number listed. There are specific laws and rules that employers must follow in order to employ someone under the age of 18. Before hiring minors in your workplace, you must get a minor work permit endorsement on your business license, get a completed parent or school or summer authorization form, and verify the minor's age. Please keep a copy of one of the following on file: the birth certificate, the Social Security card if there is one, driver's license, baptismal record, or notarized statement from a parent or legal guardian. You must follow the legal age to work, job duties restrictions, hours of work limitations, applicable meal and rest break requirements, and appropriate wage requirements. The legal age to work in Washington is governed by state and federal child labor laws and varies based on type of work, whether the job is considered hazardous or has prohibited duties, whether school is in session, the legal status of the minor, and whether the job is exempt from the Fair Labor Standards Act. For more information on youth employment questions, see the link at the bottom of this slide or contact the LNI Youth Employment Specialist, Josie Bryan, at the phone number listed. RCW 4960-515 requires employers to provide isolated workers with certain protections to help prevent sexual assault, harassment, and discrimination. For purposes of this statute, an isolated worker is defined as an employee working as a janitor, security guard, hotel or motel housekeeper, or room service attendant. For these workers to be considered isolated, they must also perform the majority of their work alone without another coworker present. Right now, employers subject to this law include only hotels and motels, retail entities, security guard entities, and property service contractors, janitorial services. Hotel and motel entities with more than 60 rooms were required to be in compliance with this law by January 1st of last year, and all other employers subject to the law had to be in compliance by January 1 of this year. The statute requires these employers to adopt a sexual harassment policy, provide mandatory anti-sexual assault, harassment, and discrimination training to isolated workers and their managers and supervisors, provide information about available resources and protections for reporting violations of state and federal laws, rules, and regulations, and provide a panic button and emergency contact device to each employee described on the previous slide. Property services contractors have additional reporting requirements under the law. Property services contractors are persons or entities employing workers to provide commercial janitorial services for another person, or employing workers on behalf of an employer to provide janitorial services. For more information on isolated worker, please contact the L&I Isolated Worker Specialist Tiffany Osborne at the phone number or email listed. And now Sylvia will talk about termination and retaliation.
Thank you, Bob. The Employment Standards Program covers the Minimum Wage Act protections, but we do want to touch on this termination and retaliation very quickly. So Washington is an at-will state. This means employers do not need to establish cause or give notice before firing an employee. However, workers are protected from termination or retaliation for exercising a protected right or filing a complaint under certain employment laws. So let me go to the next slide here. Okay, so worker protections from discrimination and retaliation. So the Department of Labor and Industry's Employment Standards Program protects workers under the Minimum Wage Act protections, protected leave, Equal Pay and Opportunities Act, and other L&I protections such as workers' compensation, discrimination, and safety and health discrimination. However, on the right-hand side, we do have other agencies' information that also have anti-discrimination programs, and we have that here and hyperlinked as a resource for you when you receive this PowerPoint. An employer cannot retaliate or take any adverse action against employees for exercising a protected right, filing or intending to file a complaint, or discussing potential violations of their protected rights in regards to minimum wage, overtime, tips and gratuities, accrual and use of paid sick leave. The Employment Standards Retaliation Unit investigates prohibited adverse actions towards employees. Examples of this are when an employee has exercised a protected right and an employer terminates, suspends, demotes, or denies a worker of a promotion, reduces hours or alters the employee's work schedule, reduces their rate of pay, threatens to take or taking action based upon their immigration status or that of a family member, or subjects them to discipline, which includes write-ups, verbal warnings, or points as examples. When it comes to wage complaints, employees have the right to file a wage complaint against their employer for unpaid final wages, unpaid agreed wages, unpaid overtime, unpaid minimum wage, tips and service charges, unpaid paid sick leave, and non-sufficient funds checks received as a wage payment, or for unauthorized deductions from their paychecks. So what does the wage complaint process look like? So we've condensed the process on this flow chart for you here. When the department receives a complaint, it is then assigned to an investigator. The investigator reviews the evidence provided, and the department will make one of the following determinations. If wages are owed, the employer can pay and the case is closed. Or if the employer does not pay, the department will issue a citation and notice of assessment and will attempt to collect those wages. However, if wages are not owed, the department will issue a determination of compliance and send the worker a copy with their appeal rights. And as a side note, L&I may investigate pay owed to other employees working for the employer. Finally, the department also investigates non-wage complaints against employers for the following reasons: meal and rest periods not provided, child labor violations, retaliation due to a protected activity, protected leave violations, Equal Pay and Opportunity Act violations, and farm labor contractors who are not properly licensed. And now I'll hand it over to Tiffany to walk us through some tips and resources that are available for you.
Yeah, so we're going to wrap it up here with some helpful tips and resources. And this is just to give you an idea of some steps that you can take to be in compliance with the regulations that we went over and to avoid getting any possible wage or other workplace rights complaints. So first, it is highly encouraged that you review your organization's policies closely to make sure that they comply with state laws. Sometimes a complaint will come in and we'll see clear violations that are stated in the company policy. So you want to go through that and make sure that these do not go against any employee worker rights regulations. Secondly, you should ensure that the job duties the employee is performing actually reflect, or excuse me, the job descriptions that the employee, that's for the employee is actually reflecting the job duties that they perform, because this is important to substantiate gender equality in the workplace and for the purposes of the overtime exempt administrative, executive, and professional employees, since there are duty requirements for these. Another suggestion is to conduct periodic self-audits of your organization's record-keeping practices. So some employers have chosen to do this quarterly, some monthly. Whatever you decide is the best fit for your organization, depending on how small or big, would be up to you. But that could also help you to review that information and make sure that you are staying in compliance. Another tip is to conduct frequent training for management and supervisory staff. And many of the violations that we have seen occur are received due to like a manager or a supervisor perhaps not knowing all of the regulations, for example, for required rest breaks or for tips. So just making sure that they're getting that information and updating even current staff as a refresher course would be a good step to train new staff and also to keep those discussions going. You can also check our L&I website frequently for important updates for the Employment Standards Program. In the next slide, we will show you how to navigate through those. And you can sign up for important employment standards related information through our subscriber portal. So when new updates come out or relevant webinars, presentations, etc., you can be alerted via email. And we've provided the link below where you can sign up for that portal. All right, so now we want to take you to our L&I website to kind of walk you through and how you can access our information regarding our program. So we're in the main website at lni.wa.gov, and we're going to go over to the 5th tab, the top there, where it says worker rights or workers' rights. And then it'll drop down some categories. So this is information on wages, workplace policies, agricultural policies, pretty much everything that we talked about in our presentation. So you can find that information on our worker rights tab. But we're going to go to wages for the purposes of showing you how this works. And let's click on minimum wage. So when we get to this page, at the top, you'll find some information of what the current minimum wage is, some local minimum wage rates. We scroll down a little bit, you can see more information regarding the future minimum wage, tips and service charges, etc. We scroll up a little bit. On the left-hand side, there'll be subcategories under minimum wage, where if you're interested, you can see the history of Washington state minimum wage, some workers that can be paid less than minimum wage, and also interns, apprentices, volunteers. And then below that are some subcategories that are in relation to wages. So there's one from overtime, where you can find information regarding the requirements for overtime, like certain employees that are exempt. And then there's a tab for getting paid that has more information about hours worked and the pay requirements, and so on and so forth. We have more information on the topics we discussed. So we do encourage you, if you have time, to go on our website under worker rights and just kind of surf around and see what information you can find on there. And hopefully it's easy to find too. If not, we do have another resource for you, which is our customer service staff. So our customer service team is in the office Monday through Friday, 8 to 5, and they can answer any general questions that you have regarding workplace rights, what we discussed today. So we have their information here, their telephone number, and also their email. If they are not able to answer your question, they'll be able to forward you to a specialist that can answer your specific questions. Before we take questions, I did also want to mention that we have other webinars that we are offering as part of our outreach efforts to the community. So if you go back to our website and you scroll down the very, very bottom, you'll find a tab, or excuse me, a link that says Workshops and Training Center. So if you click on that, it'll bring you to our workshop calendar. So there's general L&I workshops, but the workshops that our program is offering is the Employer Guide to Worker Rights, which is the presentation that we're currently giving to you. But we also have a presentation on the Equal Pay and Opportunities Act, which is that gender equality in the workplace. And we have a presentation on overtime exemptions for workers that are exempt as executive, administrative, professional workers, other white collar workers. There's a training on the 25th, I see here, for the new isolated worker reporting system. And then we have a Know Your Worker Rights presentation, which is this is directed more toward employees, but of course anyone's welcome to join. And these are also available, or I guess just a couple of them. The Employer Guide and the Know Your Rights are available in Spanish. So if you know of any organizations for that, yeah, you can go ahead and contact us and we can get that coordinated. So we want to just say thank you for your time. We appreciate you taking time out of your day to listen to our presentation, and we hope that you found this information helpful. There has been some questions in the chat box, but if you have any other questions, please feel free to send those to the chat now, because we have a few minutes to answer those. I'm not seeing any questions coming in, which is fine. If you can think of anything after, you can send us an email. We're going to be following up. I don't know if we'll be sending the PowerPoint to one of the organizers. I'm pretty sure that's okay. Perfect. So that they can forward the PowerPoint to you. So you'll have our contact information and also a copy of the slides.
Wonderful. Awesome. So I'll just check the chat one more time since I get private messages. I will check that. Okay, and so will this presentation be available, this PowerPoint presentation, when I send out the link? Can I also send this presentation?
Yes.
Yes. Awesome. Okay. Perfect. Something just came up in the chat.
I'm not quite sure I understand the question.
This is a meeting setting, so if you are big, if you're able to unmute yourself, you can ask that question directly with a little bit more information.
I can drop the LMI coronavirus related requirements and guidelines into the chat box. If that's helpful, it's from our safety and health unit, and they have addressed some of the guidances there. So I can just drop that as a
Yeah.
resource through the chat
So
box.
anything related to anything, oh, that's okay. I think anything that's related to the coronavirus outbreak in our response as LNI, as far as safety and health goes, would go directly through our safety and health program, which is called DOSH. So Sylvia just linked a page there so where you can find more information through DOSH, which is a different program. So if you're looking for more information on those requirements, you'll need to contact DOSH, which is the safety and health program. Hello? I think I can
Let's see if
hear.
this works out. Are you able to hear me now?
Yes.
Oh, perfect. Yeah, I'm sorry. I finally got it to work here. So, yeah, no, thanks for that. Yeah, it came up as just as a question of curiosity because when that happened, it was difficult to determine what would be a workplace safety requirement that would make sense given such a unprecedented event. And I was just curious to know how you all came up with the guidelines to be put in place for workspaces in that regard. So, but yeah, that's a helpful resource as well. So thank you.
You're very welcome. Any other questions? Just for we have a few more minutes left, but I want to make sure. Okay. All right, so if you have any other questions after the webinar, just feel free to get in contact with us then, and maybe we'll see you at one of our other presentations.
Yes, and thank you so much for presenting for us today. As Zenobia mentioned, this presentation will be recorded and will be available for you to view on our YouTube channel. So if you have not subscribed, go ahead and do that. I will be sending a follow-up email within the next day or so with the recording and the slides for LNI, and we will definitely, have your contact information. If you have any other questions, feel free to email us or email the staff directly. And again, we do appreciate you guys presenting for us. You guys have a great rest of your day. Thank you all for joining.
Thank you.